Okay, so next up, we are going to have a panel discussion on cannabis do's and don'ts for employers. We have an excellent panel of attorneys. This is going to be moderated by Justin Zaremba, is a lead reporter with New Jersey Cannabis Insider. This is a weekly intelligence briefing from the Star Ledger and NJ.com that provides comprehensive coverage of every aspect of the cannabis industry, from the ongoing legislative efforts to legalize recreational marijuana to news about cannabis-related finance, real estate, and security. Allow me to welcome Justin. And Justin is going to introduce our panel.
Thank you very much. Thanks very much. All right, introducing our panel. Jonathan Ash, Esquire of Fox Rothschild. We have a lot of great attorneys here. We have Leo J. Hurley, Connell Foley. We have Laura Link, Esquire of Archer. Thank you. We have Jason J. Red, Esquire, Director in the Government and Regulatory Affairs Department of Gibbons, PC. Thank you. Give him a round of applause, everybody. All right, Jason, let's start out with you getting the first question here. What, if any, impact is New Jersey's medical cannabis program having on employers in terms of employees being impaired on the job and workplace accidents?
I think it still kind of remains to be seen what the impact of the medicinal cannabis program is going to have in terms of employers. I think the commissioner and Bill kind of talked about that during their remarks, because up until kind of the end of the Christie administration, and then definitely under Assistant Commissioner Brown and the Commissioner of Health, this was very much seen as kind of a program for folks who are kind of like at the end of their life. Like, it was very restricted. There was a high stigma about it. People weren't taking advantage of it. And I think you see the numbers that the commissioner talked about, the exponential growth under his leadership. And I think it remains to be seen kind of what that impact is going to be. And we're going to start to see that kind of impact the workforce with the expansion of conditions and everything else. So I think it's still a little bit early on that to kind of see what that impact really is. Okay.
Laura, Leo, Jonathan, would any of you care to weigh in on that?
I mean, I think one of the big issues here for employers is the intersection between drug use and disability, and so that is really the line that we're dealing with. And so it was mentioned before that the law explicitly states that employers don't have to accommodate medical marijuana use, and there has been a couple of cases that have been decided fairly recently about this issue, and I think that going forward, for employers, if you have an employee that's in a safety-sensitive job, your view on the matter is going to be a little bit different than an employer, who's got an employee that's, sitting in an office somewhere. And in terms of the issue of impairment, the question earlier about, how to detect it, that's a difficult task for employers, and I don't think that it's fair to place that burden on the employer to determine whether or not somebody comes in and is impaired. Certainly, if they're exhibiting signs of impairment, an employer is going to have to make a judgment call the same way that they would if somebody is on Percocet or something else. And I think that judgment call again is going to have to balance the nature of that employee's position and what their role is.
Laura, would you like to add something?
Yeah, sure. This is obviously the issue that's on everyone's mind, right? We're all getting lots of calls of how am I going to keep my workplace safe? What am I going to do? I'm going to have people showing up high all the time. I think the advice that I've been giving employers is just stay calm, okay? Because we don't know that the expansion of the medicinal marijuana program actually results in increased consumption, okay? There's no reason for us to believe at this moment that because that program is expanding, because we're considering adult use legalization on the state level, that all of a sudden, people that came to work sober every day are going to start coming to work impaired every day. Okay, so we just need to slow down, but there are a lot of things that employers can do to be proactive about this. And basically you treat it like you are already treating employees that are prescribed any other type of impairing drug, okay? You have employees all the time that are being treated with Percocet and other sorts of drugs that are impairing. And the way that most employers deal with that is they require their employees to report to them if they're going to be under the influence of anything that would affect their ability to perform their job safely. You do the same thing here.
Okay, so keep calm and carry on right now.
Right.
Okay.
We should get shirts.
Leo, if you can take the next question, kick it off. Has there been any litigation regarding employers taking adverse action on medical cannabis patients failing employer drug tests? If so, what have been those results?
Justin, thank you. There has, and I think the most important case to talk about today is a case that was litigated in the federal court with a decision that was entered last August. It's called Cotto versus Ardagh Glass. And Cotto versus Ardagh Glass deals with the intersection of the CUMA and the law against discrimination. And in very brief terms, because I don't want to bore everybody with too many details, but it's important to know a little bit about it. Cotto is an employee of Ardagh Glass. Cotto hits his head on a forklift. He goes out on disability. Before he comes back, he is told that he needs to take a drug test. He says, I'm not taking a drug test. I don't have to. Because I used medical marijuana, they said, you do have to take that drug test to come back. It turns into a law against discrimination claim. The matter is litigated at the complaint stage, at the very front end, before any discovery is taken. And Judge Kugler, in the federal court, dismisses the plaintiff employee's claim against the employer. And the basis for the determination of dismissal that there is not an LAD claim that is right based on the employer's decision not to allow him back and not to give an exception for that drug test is because there's a determination made that that is not a protected right, a protected activity. The employer does not have to accommodate the desire not to take a drug test. The judge determines that the CUMA does not provide that right to an employee. I think the most important part of that decision is a statement by Judge Kugler, who's in the federal court, that says this court predicts that the New Jersey judiciary would reach a similarly obvious conclusion. The LAD does not require an employer to accommodate an employee's use of medical marijuana with a drug test waiver. Why that sentence is important is twofold. First and foremost, as we sit here right now, our highest court has not dealt with this particular issue. Second, God bless Judge Kugler, and with all due respect to him, it's his job, of course, to attempt to determine what the New Jersey judiciary would decide. But if I was able to do that with a 100% kill rate, I'd be making a whole lot more money than I am. The judiciary can tend to be erratic on these issues. The point of saying that to you all is we're still kind of in a Wild West atmosphere when it comes to how our state's courts are going to interpret these things. With the coming of some legislation down the pike, this may get clarified by the legislature rather than by the courts, but for now, the real authority on adverse actions is this one federal case that interprets our state's law against discrimination. And it's an employer-friendly decision.
All right, thank you. Anybody else care to weigh in on that? Okay, moving on. Jason, what should employers do in terms of establishing workplace policies that will help protect their workplace and their ability to take an adverse action against an employee who does not adhere to those policies?
I mean, I think Laura said it really, really well in her response earlier today. I think it's just, making sure that you outline things like with any other substance. I think also consistency is really key as well. Like treating everything consistently is going to serve you the best if you have to proceed down that path.
Okay. Anyone else care to weigh in on that?
Yeah, one thing that you might want to take a look at is if you already have an existing drug and alcohol policy, you might have a provision in there that says something like you can't have any illegal substances on the premises, or you can't come to work impaired, under the influence of any illegal drug. Obviously, this, cannabis is still illegal on the federal level, but you might have employees who don't understand that distinction, especially if the adult use bill goes forward. They're going to think, oh, it's legal now. And your policy language might actually not cover that. So you might want to just go back and tweak your language a little bit to make sure that it encompasses, that you include language that says you can't do it in my building, you can't have it in my building, and you have to let me know if you're on it, if you have a safety-sensitive function.
Okay, thank you. Are employers still permitted to engage in drug testing regardless of whether the use of recreational marijuana is legal or medicinal, or the medicinal program is expanded? Jonathan?
Yes. Yeah, no, you can drug test. This isn't going to prevent employers from drug testing. I think that Laura raised a really good point about the policy, because I think that the job of every employer is to set expectations with your employees, and so the drug testing can go forward, and it's just a matter of how is the employer going to treat a positive marijuana drug test. And I think, again, it depends on the nature of that employee's position. It depends on a lot of different factors, and a lot of it still remains to be seen as to whether or not a decision based upon that failed drug test is going to be considered discriminatory or in violation of any of our anti-discrimination laws.
Leo, you look like you have something to say.
Yeah, I think that's exactly right, and I think that really is the upshot of the case that I just talked about. I mean, the only authority we really have at this point is this decision from the federal court down in Camden that absolutely says not only can you still drug test, but the refusal to submit to a drug test does not create a claim that if you decide to take an adverse employment action related thereto, that somehow you're going to be held liable for that. Again, the important point here, though, is that's the federal judges interpreting state law rather than state judges interpreting state law. So it's something that I think that as this progresses and as we move down the field in this rapidly developing subject matter area, business area of the law, in this new intersection of recreational and or legalized marijuana as it comes, you need to be very mindful of how the law develops in that regard. And it can change on a dime.
Laura?
Yeah, and I'll just add, just remember that all the same rules that apply to drug testing still apply, right? So again, in the theme of my please stay calm advice, there might be employers that have this knee-jerk reaction of thinking like, okay, I need to go out and start randomly drug testing everybody in my building because they might be showing up to work under the influence. Remember, in New Jersey, you can only randomly drug test employees who are in safety-sensitive functions. Okay, this doesn't change that. So just be careful about having these knee-jerk reactions and overstepping the bounds of the law in that respect.
Okay, thank you. So what happens when an employee has medical documentation permitting or requiring the use of cannabis for the treatment of a medical condition? Must an employer now permit the employee to smoke or consume on the workplace or disregard a positive test? You kind of know the answer to the first part, but anyone, who wants to jump in on that? Jason?
I mean, I think we've already discussed it. It's there's nothing that requires you to treat it differently than any other substance. You don't. There's no shift here, so I think we've kind of hit it.
Yeah, I'll add that. So the language in the medicinal bill right now says that employers do not have to accommodate the use of medicinal marijuana in any workplace. Okay, that's the language, in any workplace. And now we have this federal decision that Leo talked about, that's employer friendly and has gone in the direction that some employers want to see. But the states haven't taken up this issue yet, and I think that what we're going to see is we're going to see a battle in the courts as to what that language means. Does that mean that if you have an employee who's prescribed marijuana, can they smoke marijuana on Friday night if they don't have to come to work until Monday? Do you have to accommodate that? Because that's not in any workplace. That's at home and off hours and not in your building. The courts haven't addressed this yet. I'm sure that they will, and I'm interested to see how they go. My personal, if I have the crystal ball, maybe I'll make a lot more money one day too. I don't really think the state courts are going to follow Judge Kugler as we move forward. I think that we're going to see courts in New Jersey becoming more and more accommodating to this issue, especially with the backdrop of the opioid crisis. Because what you're seeing is a push to prescribe medicinal marijuana in lieu of opiates, and there are all sorts of public policy reasons to support that. So the workers' comp judge who issued a decision a few months ago requiring a carrier to reimburse a patient for the cost of medicinal marijuana wrote a very lengthy opinion in which he cited that exact policy, that it was, as a matter of public policy, it made sense to issue that decision in order to avoid the prescription of opioids. So, should be interesting.
Jonathan?
Yeah, and I think one thing we haven't really talked about yet is in the context of hiring, because a lot of employers will drug test at the time of hire, and I think that is a whole other minefield that we'll need the courts to weigh in on, because what could ultimately happen is an employer that's giving a conditional offer of employment that says it's subject to a drug test. You have a candidate for employment that discloses that they're likely going to fail that drug test because they're prescribed medical marijuana for some underlying condition, and then ultimately that person doesn't get hired. I can see a challenge to that decision, and it would be a difficult position for an employer to be in to say that the disclosure of the disability was not a factor in the hiring decision versus the potential failed drug test. I think that's like a slightly different scenario than the federal court case, and I don't know how that would play out, but I certainly think that court in New Jersey, I kind of agree with Laura that state court in New Jersey would look at that and say, well, what's the nature of the position? Is that really a good reason not to hire this person? So I don't know, but I think that comes up a lot. Even in non-safety sensitive positions, employers will sometimes drug test at the time of hire, and so there's a lot stronger likelihood that if you run into someone who's taking medical marijuana, that you're going to get a negative test or positive test, failed test for that person.
Sure. I mean, I know that in states where legalization has occurred, that is one of the considerations that employers have had to take into place, whether or not the drug testing at time of hire can limit their access to a highly qualified talent pool. So I think that's definitely something that's going to have to be addressed. Now, if a worker has a medical reason to take cannabis, can New Jersey employers penalize them if they fail? Anyone? Leo.
I think it goes back to something Laura brought up about safety-sensitive positions and the testing in those positions. Certainly, the guidance that we have at this point is that someone can't refuse to submit to a test based on a medical marijuana prescription. The logical extension of that from Judge Kugler's opinion is that if they do fail a drug test in a safety-sensitive position, there can be an adverse employment action taken. But again, to the points that have been raised across the board, we really do need the New Jersey courts to weigh in on this. And to echo what Laura said earlier, I tend to believe and would predict that the state courts in New Jersey, just based on their makeup, are going to be a bit more permissive as a general rule on this issue. But that doesn't mean that there's not going to be a fight. I think it's something that is going to wind up being litigated to the Supreme Court because it's an issue of fairly significant moment under the law against discrimination for employers and employees, and it's new. So it's you're as of right now, it's an employer-friendly environment in that regard.
Okay.
One thing I just want to add too is if we're talking about a position that federal law requires testing for, that is certainly going to trump the state law. So that's a question I've been getting, very frequently is, well, these are employees that are subject to the DOT regulations, or we have this federal contract, we're a government contractor and our contract requires that we do drug testing. In those cases, the language that's been kicked around in the recent bills on legalization of adult use have made it very clear that in those cases, the federal requirement would trump.
And that's something that's very important for employers to keep their eye on, is when dealing with these things on a prophylactic or proactive basis, making sure that when you're contemplating how to approach those issues, making sure that the position you're talking about is not a federally regulated type position, because you're going to have a different paradigm for that than you would that you have to analyze than one that is not federally regulated.
All right. We already touched on, skipping the next question, we already kind of touched on this, but Is it legal or ethical to ask a job candidate if they hold a medical cannabis card? As a potential employer, don't you have the right to know? Laura?
I wouldn't say right to know. I said, would you want to know? So this gets back to, why are you asking? This might be information you don't want to know, right? So in other contexts, I tell employers, be careful about diving into Facebook or diving into Google, because you might learn something about your employees that you don't want to know, like they have a medical condition. And then that applicant is armed with a potential claim that whatever decision you make towards their application or whatever decision you make towards an employee's employment is based on your knowledge of their medical condition. So once you ask this question, you can't close that box back up. Now, you might have very good reasons for asking that question, like Leo and I just discussed, because if it's a federally regulated position that has to undergo drug testing, I mean, maybe there's a very legitimate reason for that, but just tread carefully.
Yeah, if you feel the need to ask that question, then in all likelihood, your job requires drug testing at the time of hire anyway, and I would just not ask the question and see if they pass the drug test. That's a lot safer than inviting the individual to disclose a medical condition that could then result in a claim.
All right, thank you. Leo, even if if employer rights provisions are part of legislation that would legalize recreational or adult use cannabis and expand the existing medical program, what should employers still be wary of if and when it becomes law? When?
I think that's really the most important tie it together question today, and I think the best answer that can be given to that is to remember that the devil's going to be in the details of whatever the new legislation is, and it's a question of being mindful of that, mindful of when it takes effect, and having, I would suggest, a robust HR counseled analysis of what that means for your particular business. If you've heard us today, we've talked about a whole lot of different moving parts: federal jobs, non-federal jobs. Does the job have a safety element to it, et cetera? What is written into that legislation is really going to dictate the rules of the road. So it's a question of knowing when that happens and reacting to that when it happens, and being prepared for that. It's a question of just seeking counsel, I think, at that point.
This is actually where I'll kind of do what Bill did and put on my legislative staffer, Pat. In addition, I would say that this is also where you really work with BIA and Mike Wallace to make sure that the legislators know how this will impact your business, and really make sure that you get in there and they understand it. There are businesses in every district throughout the state, and I think that you need to tell your story and back up NJBIA so that while it's still in this phase where it's still being developed, that the language is in there so it's clear, so that these things don't have to be litigated, that it's very clear in terms of how you interact with your employees, and it's not left up to judicial determination. So it's really important, and I would just put in my plug again for BIA to really work with their legislative team to educate the folks who are going to vote on this.
All right, thank you. Let's open this up to questions from the audience.
Hi, Craig Weiss, Consumer Product Testing. You keep saying a security, a job that requires security, it's okay to discriminate. What would you consider a security job? I mean, I run a laboratory. I have chemicals. I am licensed for Schedule 1 through 5 drugs. So I have to have security on that portion of my business, but on the same token, there's a clinical end to that business that I don't need security because it's primarily cosmetic. So where do I draw that line?
First of all, none of us told you to discriminate against your employees.
No, Laura did. Laura did. I heard her.
Okay, you implied.
Just to be clear, that's a great question. So, there's no there's no definition that's been set out very clearly of what is and what is not a safety-sensitive function. And this has been very frustrating for employers for a very long time, because the law is that you can randomly drug test safety-sensitive functions, but otherwise you can't. So we've been expecting the courts to fill this gap in, but I think that that gap has now extended for almost 20 years. So what do the New Jersey cases say on it? We know that police, firefighters, forklift operators, individuals, driving large apparatus vehicles, trucks, things like that, you can put them pretty safely in that safety-sensitive function. But I've heard damn good arguments that accountants should be safety-sensitive functions and all other kinds of things from employers. And I'm like, oh, that's great. We're going to have to fight that in the courts if you want to stick by that. But there's no hard and fast definition, unfortunately.
Thank you.
Next question. I recognize that guy.
Angus Reid, when do you expect to see the federal laws passed?
I think the government has to be open first. No.
That'd be a start.
Yeah, I mean, I don't know. I work out of Gibbons, Washington, D.C. office, and it's just, I think that there's definitely momentum there, but I think that they've got more pressing things that are kind of at the top of the agenda right now down there.
My personal opinion is if we do go forward in New Jersey with the adult use, you should all lobby for it to go forward on the federal level so that you don't have to figure out this terrible burden and gray area of which law you're supposed to be following, regardless of your opinions on the matter. It'll just be much more clear once this gets taken up on the federal level. But I think there's movement already. I wouldn't be surprised if it happened in the next 3 to 5 years, but I'm no expert on that.
Yeah, I'm not an expert either. I think that Jeff Sessions no longer being the Attorney General may break the dam a little bit, but I would be hard pressed to say that I would think that it's going to happen during this next 2 years. I tend to think that you're going to need, not need, but it would almost require a Democrat in the White House to sign that type of bill.
Yes, I just want to follow up with Laura. You said to have your policy be very clear as to what you're banning in the workplace. Mm-hmm. Should it be marijuana, cannabis, cannabinoids? What would you put in a policy to be specific as to what specifically you're banning?
Yeah, medicinal marijuana, cannabis.
Okay.
Yeah. In addition to illegal, illegal substances.
Hi, Scott Rutter from New Jersey Cannabis Business Association. So we're talking a lot about drug testing. Out west, a lot of corporations, a lot of companies are adopting impairment testing because of the THC and how long it can stay in somebody's system, even though they're not impaired. 2 weeks ago, they had a joint. 2 weeks later, they get tested, and then they test positive. Impairment testing. What would the challenges be in New Jersey to start to adopt impairment testing? Because that would go for opioids, Valium, Xanax, cough syrup, whatever. So not just cannabis, but all other substances. Because the real concern for most people is this person going to hurt themselves or others in the workplace? And if a person is sober but tests positive for cannabis, that creates the challenge. But the same thing happens with opioids and other prescription drugs that could impair the person. So what would be the challenges of adopting something like an impairment test, which is something that is going on in other states?
Look, I'm not a scientist, but I'm not aware of any testing that can actually measure impairment. I know that there are efforts to develop that technology. If you're in this room and you know about that, I'd like to talk to you. I have some money for you. But no, but I know it's being developed. But I don't think that there's any tried and true method just as of yet. But I think that once that develops, that's going to be a fantastic tool in this area. And you would, my advice to employers would be to use that in conjunction with observation, right? Reasonable suspicion testing. You see someone being impaired, you document it. Are they slurring their words? Fumbling around, acting in an unsafe manner?
Yeah, I think that's the real point here. The tech isn't there yet in the way that a breathalyzer is for alcohol. So now you're at a personal observation point of view in terms of impairment testing, and I mean, that's a ripe litigation situation, if you ask me. If we can fight out the results of a breathalyzer test, I can only imagine what the fight would be in terms of what someone's personal observations would be as to impairment.
Right. There might not be like a scientific way of testing impairment right now, but like police officers go through training to determine impairment, and to make employers, designate a person, like who's that going to be? The HR person is going to go through some kind of like police training to determine whether or not someone's impaired, and they're going to make that judgment call on an individualized basis. That seems very problematic. So I think that would be a huge challenge, not only to actually implement it, but then it would also require some kind of investment as well from the employers to put that person through that training. It just seems like a whole big problem.
One just thing to add, the further this moves down the field in terms of legalization on this state's level and on every other state's level, the tech will catch up, because there will be a need for that, and it will incentivize someone to put money into what becomes a necessary product. But I do think, like I said, as legalization moves down the field, that type of tech is going to evolve. It's going to have to.
Yeah, and despite me telling you all to remain calm, don't let this legalization paralyze you from policing your workplace and making sure that it's safe. And so if you have concerns that somebody who's operating a forklift or doing some sort of safety sensitive function, if you have concerns that they're impaired and that they're not able to perform their job safely, you should take action, right? You shouldn't think like, oh, well, maybe it's the fact that they have a prescription and I don't want to go down that road because a bunch of lawyers told me that I would be discriminated against them. That you should definitely take action. You should document what you see that leads to your suspicion that they're impaired, and feel free to and absolutely stop them in their tracks, and stop them from operating that forklift, and go do a drug testing if that's in your normal course, or whatever, however you treat any other employee that's impaired under any other substance.
Thank you. Mike Delisio, Brooker. We are a manufacturer in Carteret. Twofold question. First is, we had a policy whereby when an individual was hurt on the job and was sent to a clinic under workers' comp, we would routinely have them drug tested, and then we were advised not to do that. So we have stopped that. So from the testing perspective, do you still think that is a prudent course of action? And secondarily, as we move towards recreational marijuana usage, is that something that if we did a 9-panel test for a new employee that we could reject their candidacy?
I'll address the first issue. I don't know what the advice exactly was based off of, but I can tell you that OSHA issued a rule within the last 2 years. I can't recall if it was 2016 or 17, but where they issued a rule indicating that you can't do blanket drug testing after workplace incidents. You have to have some sort of suspicion that impairment led to the accident, and that needs to be the basis for sending an employee to undergo drug testing. So yeah, so that's the issue with the blanket testing. But if you have suspicion, I would stick with the practice of doing the drug testing.
And I think that to piggyback off of that point, if you have the suspicion, as Laura said in answer to the last question, make sure that you're documenting the nature of the suspicion contemporaneously with the time that you are asking for that. You need to be able to justify that at the front end rather than at the back end.
And the second part of your question on the hiring, if somebody fails a drug test, you can not hire them for that reason the same way as anyone else. The issue is just if that person had disclosed to you that they have a medical condition, I think you're getting into a little bit of a gray area with the discrimination laws, because I think that they would have an argument that the decision was not based on the drug test, but based on the disability.
So my question, though, is if it becomes legalized for adult usage, right, and then you have a new employee that goes for drug testing, they test positive for cannabis, you can deny them employment based on legal
actions, right?
I think the problem is that your question is premised upon a predicate of if it becomes legal. We don't know what the terms are of the legality. We don't know what the legislation that is going to come down is going to speak to, not just in terms of legalizing it generally, but what that means for employment purposes. I think that to Jason's point earlier, the more clarity we have on those things that can be addressed through the BIA so that it's not something we're fighting about down the line, the better. This needs to be, in a best case scenario, in a perfect world, that type of issue, if not addressed on all fours, is addressed in some fashion in the hypothetical legislation you're talking about.
Yeah, I mean, my thought on that is if employers currently don't have to accommodate medicinal marijuana, why would they have to accommodate recreational marijuana in that scenario?
Yeah, we're just going to have to see what the language of the final bill is, because there has been language kicked around that would make that action illegal under state law that says that you can't take an adverse action against somebody for having it in their system. So, so we're just going to have to see what the final bill looks like. That being said, keep in mind, if it's a federally regulated position, that would trump.
Just Bill Lillis from the Partnership for Drug-Free New Jersey. We're grant funded to assist businesses on the issue. Can you comment a little bit about education for what employers could do? And just two quick comments. One, a story we had from a town hall meeting where a mother had to bury her 27-year-old daughter because a coworker shared a Percocet with the 27-year-old who's in recovery. So that's an example of what could an employer have done. So in terms of educating individuals on should it be legalized or medical marijuana, what recommendations would you have for people on that?
If I understand your question, you're asking what education should be given as to whether this should be legalized?
No.
No?
So how would you educate? Let's say it's legalized. What steps should an employer take? What steps should an employer take now with medical marijuana being expanded? How can they educate their employees on the issue?
I understand it now. I think that if it is legalized, if it moves further down the field, I default back to what I think we've been saying holistically throughout this presentation, and that is the legalization and what it means for businesses and what it means for society generally is going to be a function of what the words in the final bill are. We don't know right now what the language is that Laura has talked about that has been kicked around as to how it applies to employers and employees is going to look like when the sausage finally gets made here. Once it's made, my suggestion would be that an employer sit down with their HR department and or their outside counsel and determine how the changes in the law are going to affect certain HR policies. I don't think it's something that an employer should just say, oh, okay, that's legalized now, let's just continue making widgets. You need to engage it because it's going to have effect on your internal human resources policies. That would be my suggestion. It should be a thoughtful approach rather, and a reactive approach in a sense, based upon the verbiage of what is going to be controlling how you run your business.
Any more questions? No?
We solved it.
Great. Congrats. Hey, everybody give a big round of applause to this panel. They've been fantastic.
Yeah, solved it. Okay. That's a lot to think about. You know, just a couple of wrap-up thoughts here. We do need the New Jersey courts to weigh in. You know, I wrote that down. That's a little bit scary in and of itself, considering that we do tend to lean to an employee rights state. So as employers in the room, we should be conscious of that. But there's a lot in that process. You know, anytime a case goes up, you always got to make sure it's like the right case with the right facts, right? So that when you interpret the law, you're making good law. And so as an attorney myself, that's where I get scared when Laura says, you know, kind of stay calm and carry on. The business as usual. This is a lot more of the same. A lot of the policies policies you have in effect today will have to morph. But you have policies in place that cover this in a more holistic manner. But we do have to be careful about the type of law we're going to make on this and not be too overcompensating to run to the courts if we don't have the right set of facts, because we can make bad law for employers. And I think the thing we learn all the time is the pendulum shifts. I just go back to the whole coming of age of sexual harassment in the workplace. And in the very beginning, the pendulum was all on the side of the employees. It was, if your boss yelled at you, you got past a summary judgment motion. Right? Today, you couldn't even, get to the front door with a case like that. So this is something that's going to, probably be decades in the making of interpretation. And the court gets to interpret the law. They do get the last say on a lot of this stuff. So let's make sure we make it good law as we go forward. Yeah, BIA, we are a resource here for you. So we are monitoring this. Again, Mike is our lead on this, and Mike has all the language being discussed, and Mike's in there advocating on behalf of what we need to ensure a safe workplace and to help you all. So when this bill ultimately goes through and we get all the language that we want and need, right, Mike? Then we'll have fast facts out, which are, facts and frequently asked questions for you. We'll do programs with attorneys who can, again, talk about the law as we know it in that moment and help you work through. We'll do workshops, and we will absolutely be there as a resource for you. What do you need to do in the meantime? You need to stay close to this issue. It's significantly important. This is a game changer for our companies and for the state of New Jersey, without doubt. Engage that assistance when it comes out. Lean into it. It's not going away, right? And transparency in the workplace. Just like you have, meetings with your staff now once a year or twice a year to review your policies, and you do your sexual harassment training. You talk about what's right and not right in the workplace and set your culture, have a good culture, and we should all be okay. And I know you all have great cultures today and you do those things. So I think more of the same, but attention to detail is going to be our marching orders on all of this, and stay close to it because BIA will be there marching with you.